Shibai Ule.
Principal seat matter for pronouncement of judgment. Item 1.
Morning. Can you all hear me? I think they can't hear. phone kora. Can you hear now?
Yes.
All right, I'll just read out the operating part of the judgment. Mr. Deka, Mr. Sharma, Ms. Bhattacharjee is not there?
No, he's not there.
As noted above, the 1951 Act does not mandate the management of a plantation to provide treatment for cancer in the garden hospitals. There being no requirement in law for the management petitioner number 2 to provide treatment for cancer in their hospital for their workers and families, the respondent number 3 has no legal right to claim reimbursement of medical bills in relation to the treatment of his wife who was suffering from cancer. Therefore, in the instant case, the learned tribunal, by imposing a penalty upon the management petitioner number 2 for defaulting in providing cancer treatment, has gone to the extent of adding a new medical facility in the 1951 Act for the management petitioner number 2 to provide, has exceeded its jurisdiction and has transgressed into the role of the legislature. Any such award passed by the tribunal beyond its jurisdiction is patently illegal and cannot be enforced. That being so, I am of the unhesitant view that the Learned Industrial Tribunal has committed a jurisdictional error apparent on the face of the record in passing the impugned award dated 7/6/2004, and therefore the same is to be corrected by this court in exercise of its powers under the certiorari jurisdiction. Hence, I do so. Accordingly, the award dated so-and-so passed by the Learned Industrial Tribunal, Dibrugarh, in reference case number so-and-so, is hereby set aside and quashed. Before closing the matter, this court expresses its appreciation and satisfaction to the assistance rendered by Mr. Rakesh Sharma, Learned Amicus Curiae, who was appointed by this court with a order dated 28/3/2025 to assist this court on the legal issue involved in the case at hand. All right. Mr. Sharma, thank you for the assistance, but you will not be getting anything in this case.
Obliged.
It will be downloaded now, so you can
Yes.
have a look at it. Yes, please. Any mention?
Isol bench matter for admission. Item number 1.
My lord.
Some fresh development? Yes,
Yes, my lord.
Ms.
However,
Valentina?
yes, my lord. I would like to submit that there was some development. However, I have no concrete information as of yet. So
What
if
development?
that there was new steps taken for re-verification, my lord. So
No, because I think what was to be done was to verify and then
my lord.
acquire and compensate.
Yes, my lord.
Anyway, you want some time.
Yes, my lord. If 2 weeks time, 3 may be granted.
But you file it because if the compliance is already done, this court is not going to go further in depth because this is not the executing court.
My lord.
So there better be something substantial in your affidavit.
My lord.
Otherwise, I'm going to close this contempt. As prayed for by Ms. Valentina so-and-so, Learned counsel appearing for the petitioner, relist the matter after 2 weeks on a date to be fixed by the registry to enable the petitioner file the affidavit as prayed for earlier before this court. MS so-and-so, learned counsel appearing for the contemptness is present. List accordingly.
Obliged.
List after two, I have said, na, Mashwai?
Item number 2.
If you please, Your Lordship.
Yes, where is Mr. Gupta?
My lord, I am joining through VC, my lord.
Yes, where is your affidavit?
My lord, the affidavit has been filed, my lord.
Affidavit filed.
Affidavit is filed, my lord. My lord, in this matter, if I may pray, my lord, in the connected, my lord, the order which is put to under contempt, my lord, that is, we have filed an appeal, my lord, against that order.
What has
And the
happened in the appeal, Mr. Gupta?
My lord, it was listed on the last occasion,
Is
my
there
lord,
any
but due
stay
to
order,
some...
Mr. Gupta?
My lord, it has
Is
only
there
been
any
listed on
stay
last...
order? Is there any stay order?
No, my lord, it was not listed. It was not listed for admission, my lord. Since after the filing, my lord, it has not been listed for admission.
All right, when do you want it?
So, my lord,
Mr.
I-
Silo, I
I'm-
will post it with the other matter.
My Lord, my Lord. My Lord,
When
I
is
just
the-
want to appraise Your Lordship,
Yes.
kindly appraise Your Lordship about this one judgment of the Supreme Court where it stated that when there's a contempt matter pending, the connected appeal cannot be taken up before the disposal of the contempt matter. Your Lordship?
You see, in fact, it was, I think, your matter and Mr. Gupta the other day when I had expressed the same opinion.
Yes. Yes, my lord.
Pendency of appeal cannot be a ground for non-compliance.
Right, my Lord.
Unless, of course, there is a stay.
Yes, right, my Lord. And plus, my Lord, the purported appeal, it has an IA, which is for condonation. So the appeal has not been admitted. The condonation of delay has not been condoned.
What is the order? What is
Last
the...
sentence, Your Lordship. It is further directed
No, no,
that...
no, I am not saying that.
Oh.
The order against which this contempt, you have filed alleging non-compliance,
Your
which,
Lordship. It's
where
at
can I
page-
find that page?
Page 20, Your Lordship.
Page 20.
20, Your Lordship, Annexure 1. And, my Lord, this order was passed as it is a covered matter.
Yes.
So, if I take Your Lordship to para number 6, which is at page 31.
Yes, I have para 6.
Yes. I've heard the learned counsel for the rival parties and I have perused the materials available on record, including the earlier order of this court dated 25/10/2022, passed in WPC 115 of 2020, which is Annexure 11 of the writ petition. I therefore find that this writ petition is squarely covered and can be disposed of in a similar matter. So, Your Lordship, in this WPC 115/2022, this has been satisfied by the respondents, Your Lordship. So, it is for payment of interest under Section 28 to the landowners, which have been paid, Your Lordship. So, we have come in, since we are from the same village, from the same award, so we are claiming the same benefits. So, it was admitted by the council for the CGC that it was a covered matter. That is why it was disposed of in this matter, Your Lordship. And even though it was a consent order, Your Lordship, they have not paid, even though the other landowners have been paid. And Your Lordship, if I may kindly take Your Lordship to the affidavit file.
1 second. Go slow, go slow. Why are you in such a hurry, Mr. Silo?
Sorry, Your Lordship.
The order is very clear.
Yes, my Lord. And pursuant to this order, Your Lordship, if I kindly take Your Lordship to the next page, the order
The assessment has been done or not done?
has been done, page 33, Your Lordship.
So what remains is to make the payment.
That's it, Your Lordship.
Huh?
That's only pending.
Yes, why payment is not done till now? Mr. Gupta,
My lord,
why
my lord,
payment is
ours-
not done?
my lord-
Your time was within 6 months, 6 weeks.
My lord, my
From
lord,
the
this
date of
matter-
receipt of assessment. When did you receive the assessment? Page, assessment.
My lord, this matter was disposed of, my lord, on the
Your
first date.
Lordship, page 33
Wherein-
is the...
One sec, page,
33 is the order of the DC making the assessment. Page 33 and
that is,
34.
date is 1/6/23.
1/6/2023.
And
And the from page 35 is the assessment sheet.
this is dated and it's same date.
Same date, Your Lordship. And if I may kindly take Your Lordship to para 4. Para 4 is the letter by the respondents to
There are four of,
annexure 4, page 42. Page 42.
yes,
Here it shows that the respondents have received the assessment and they have wrote a letter to the deputy commissioner stating that certain anomalies was there. So to make a correction of certain anomalies. So accordingly, those anomalies were rectified, and Your Lordship, if you see page 43,
yes.
so page 43, the DC has made another assessment after rectifying it. After rectifying it, as requested by the respondents, rectification of the amount of assessment was made. And this assessment was made on 24 July 2023. If Your Lordship will see,
This assessment, this is reassessment,
reassessment as requested by the respondents.
page 43. This is 24/7/23.
Yes, my lord. So the earlier was 1st June.
Now, when did you file the appeal? Mr. Gupta, when did you file the
My
appeal?
lord, my lord, the exact date, my lord, I am not having. my
Why?
lord.
You are, it is you who wants
Appeal
me
the
to
date to
adjourn this
revision.
case on the pretext that an appeal has been filed and you don't know the date?
My lord, I have the case number, my lord, but the
What
exact
page
date I have.
number?
Case number, my lord.
Yes, give me the case number.
My lord, it is. We have some case number. My lord, WA number 6 of 2025, along with IA Civil
For
54 of
condonation.
25.
For condonation.
Yes.
IA
IA Civil 5425, my lord,
54?
of 25.
Yes. Delay condoned or not condoned?
Not condoned yet, my lord, not condoned.
Sorry, Mr. Gupta, this is a very sad state of affair that is going on. This is not the
My lord,
way.
if I
This
may-
is not
if
the
I may
way
submit-
that you show respect to the orders of this court. Absolutely not, Mr. Gupta. The reassessment,
be allowed to
the
submit, my lord,
reassessment
if
has
I
been
may be-
completed way back on 24th July 2023. As per the order of this court, you are supposed to make the payments within 6 weeks after you receive the assessment.
My lord.
You sit over it, and then you file an appeal, that too, with delay. Till date, the delay condonation has also been not moved.
My lord, in a similar matter.
I am
we-
not interested. What is happening in
lord-
a similar matter, Mr. Gupta? I am
My lord,
concerned
the-
with this
my
particular
lord-
case which is in front of me and it's a contempt petition. This is not a regular writ
Honorable-
petition.
It's the order of the Honorable Division Bench, my lord, wherein the Honorable Division Bench is in session of the issue, my lord, whether interest under both the sections can be paid
Is
or
there a
not.
stay order?
Yes, my lord, there
Where
is
is
a
the
stay
stay
order.
order? Show me.
We have annexed it, my lord, in the
Where?
reply which we have filed.
Show me page.
I will show, my lord.
Mr. Silo, there is a stay order.
No, there's no stay order. And Your
My lord
Lordship, the
will
matter
take,
which-
my lord will take page 29 of the reply first, my lord. Page
Page?
29. Page 29 of the reply filed by us. Filed by the respondent number 5, my lord.
Page 29.
Page 29
Of which affidavit?
of the affidavit filed by respondent number, my lord, 4. Alleged contemner number 4.
There is no affidavit of 4 on record. This
Alleged
is
contemner
affidavit in
number four.
opposition of contemner number 7, affidavit for the petitioner.
7, my lord. I'm sorry, my lord, it is 7. Alleged contemner number 7. Vinod Kumar. He is, my lord,
You
chief
want-
engineer.
You want this court to turn to page? 24.
29, my lord.
29.
Page 29. My lord, page 29 is the order, my lord, in a writ petition filed by the Union of India, my lord, wherein we have challenged the direction of the Deputy Commissioner as to payment of interest under Section 28
One
and
second,
34.
one second,
My
Mr.
lord.
Gupta. This is a different case. This is, and
It is
here,
a different case.
and here
It
the
is a
single
different
judge
case.
have said, the learned CGC, upon being asked as to why so-and-so, the name of so-and-so, therefore it is not a case that a single individual has been given an assessment for the same plot
Page-
of land. In view of the provisions so-and-so, there can also be no question of adjustment being made. Thus, upon due
Yes, yes, ma'am.
consideration of the
Page
materials.
29.
I'm
Yes,
reading,
page
I'm
29.
reading, I'm reading, upon due consideration of the materials available on record and also in view of the law laid down in so-and-so, that so-and-so is supplementary to so-and-so, this court does not
Yes,
find any
ma'am.
merit of the petition. The petition has been dismissed. Yes.
That portion, yes, my lord. That portion, paragraph 11, which my lord has just read, that the railway respondents are liable to pay interest under both the sections, that is 28 and 34, by making an interpretation that 28 is supplementary to 34. That was put to challenge, my lord, subsequently, my lord, page 30. Page 30.
Yes.
WA 8
Yes,
of
I have page
24.
30, which is the relevant
My lord,
page.
the relevant page, my lord, is page 38. Page 38, my lord.
Yes.
Page 38, my lord, will see, my lord, the operation of the order, impugn order dated
All right, I've seen it.
27/7/23 has been stayed.
All right, I've seen it. When is the next, when is the
That-
other case fixed?
My lord, that
My lord,
case,
it is posted for final hearing, my lord, it will come, my lord.
No, no,
it will-
there is another
date has
contempt
not-
petition fixed here, right?
yes, my lord.
And a
My lord,
similar,
if I may, your lordship, the.
Mr.
Yes.
Silo,
Yes, my lord.
save your energy for the next date. When is it fixed?
So, my lord,
When is
my
the
lord,
next
the
date
date
of
has not
the,
been fixed yet.
when do you want this case?
My lord, after 2 weeks, my lord, after 2 weeks, my lord, we'll take it up, my lord.
My lord, if I may, kindly, this WA he's referring to, that is the question. It
You
is a
see,
question-
Mr. Silo, ultimately this matter has to be heard.
Yes, my lord.
Today, it's not for hearing,
If I just.
right?
If I,
I understand your
it's a different
anxiety.
matter, your lordship.
Could be, but,
The order which is in contempt, it's only for payment of section under 28 only. The matter which he has referred to, the WA, has to be decided whether 28 and 34 can be both given, which is not the case here. The case here, if you see the judge, the order of the court, which has not been complied, it is only for payment of
anyway,
section
this matter
28.
has to be heard.
Yes, my lord.
Yes,
So
to
I'll
be
fix
heard.
it for hearing.
Yes, my lord.
Admit the contempt and fix it for hearing.
My lord.
All the contemptors have filed their oppositions.
Yes, my lord. No. Only.
Who is
contemptor-
appearing for the other respondents?
My lord, the affidavit filed by, it says contemptor number 7, but in the affidavit is written Vinod Kumar, which is not contemptor number 7.
No, but what about the other contemptors? Have they appeared or not?
Actually, my lord, in this matter, they have not appeared.
Huh? They have not appeared. You are only appearing for R7, Mr. Gupta.
My lord, R7 was the, my lord, the contemptor whose replies was necessary, my lord. He was the authority to implement the order. Other contemptors also, my lord, I can appear.
So then you appear, if you can, because otherwise,
But, my lord, I have to take instructions. Some
then
of
you
them
have
are,
instructions
my lord,
from them because they
they
are
are-
all
they are-
officers of the Ministry of Railway.
Yes,
Right.
my lord, but few are transferred. That is why, my lord, I have to take
No,
instruction
you
whether.
see, if someone
Yeah.
has been transferred, then that person also has to be, the new incumbent has to be also impleaded.
My lord,
At the
my
end
lord.
of the day, it is the implementation of the court's order which will be in question. So
My
if
lord.
any of these things has to be done, you please inform them, Mr. Silo
My
can
lord.
do the
My lord.
required, whatever is, otherwise he will not know there, nobody is appearing for them also.
I will inform, my lord. I will inform.
So, heard Mr. J.L. Silo, Learned Counsel for the petitioner, also heard Mr. H. Gupta, Learned Counsel, appearing for contempt number 7, who has
It would
joined
be
the
four.
hear.
It would be four, my lord.
4. For
Contempt
respondent
four.
number 4, who has joined the hearing through video conferencing mode. It appears that affidavit on behalf of respondent number 4 has been filed.
File, my lord.
On
File.
behalf of respondent number 4 has been filed. However, in respect of the other contemners, there has been no representation so far. Mr. Gupta so seeks 1 week time to obtain instruction as whether he can represent the aforesaid respondents, as they are also officers of the Northeast Frontier Railway, of which respondent number 4 is the chief engineer stroke construction chief engineer. Stop.
My-
Relist after 2 weeks on a date to be fixed by the registry.
Obliged.
Item 3.
You are appearing, Ms. Valentina?
Yes, my lord.
You are an amicus here?
No, item 3.
This is item 3, item 4. Huh? This is item 3, sorry. Yes. Respondent 4, 5 and 6, I think you have not taken steps of service.
Yes, my lord, if it pleases your lordship, I would like to make some submission. If I may have your kind attention at page number 14 of my contempt petition, my lord. The order passed in the WPC.
See, Ms. Valentina, you have arrayed them as respondents.
Yes, my lord.
Now-
However,
Now you need to take steps.
yes, my
The
lord.
court has already issued notice.
My lord,
the
if the
court-
respondents may kindly be exempted, my
No,
lord.
the notice has been issued. You should have said, made the submission on that date.
Submission was made on the 16.
On 16/1,
Yes, my lord.
notice be issued to respondents.
Yes, it was submitted that the.
So you please take steps. How much time? Because please understand that there is a judicial order whereby you are required to take notice.
Yes, my lord.
Now I cannot simply overturn that judicial order
My lord.
merely because you are not having, at this moment you think you may not need it.
My lord.
If you did not want notices to be issued to these respondents, you should have made that submission on that date, and an appropriate order, if had been passed, it would have sufficed. But now I cannot do anything.
My lord.
Right.
Understood.
So you take steps. If they don't appear, we will see what is to be done.
My lord. 1 week time may be
As
granted.
prayed for by MS Valentina Leonard so-and-so, list this matter after 1 week on a date to be fixed by the registry to enable so-and-so to take the requisite steps in respect of respondent numbers 4, 5 and 6 in terms of the order dated 16/1/2025 passed earlier.
Oblige.
List
Item-
accordingly.
Item number 4.
please, Your Lordship.
First appeal, order.
Yes, my Lord.
Yes.
AD card in respect of the respondent number 2 to 6 were received back on 25/4/2025.
May I please, Your Lordship, I'll be appearing on behalf of respondent number 2, 3 and 6.
2.
3 and 6.
What about 5?
I don't know.
5. All right. So we'll mark your appearance today. You are for?
Respondent number
1. 1 and 4, I think.
4 also has been represented, my Lord.
Yes, earlier I have seen. Who is appearing for 4?
I think none appear as of now.
Huh?
None appear
It
as of
appears they are absent in spite
Yes,
of
but
filing a
this cannot
vakalatnama.
go on like this. Last time 1 and 4 were there, 2, 3, 5 and 6 there were none. Today you are appearing for 2, 3 and 6.
Yes,
You are
ma'am.
for 1, but still 4 and 5 is missing. No use. All right, we'll give them another chance.
Yes, my Lord.
Next week,
Yes, my Lord.
Yes, my lord.
do you heard Mr. So-and-so, learned counsel for the appellant. Also heard Mr. So-and-so,
Zone
learned
number.
counsel appearing for respondent number 2, 3 and 6. And Mr. So-and-so, learned counsel appearing for respondent number 1. It appears that there is no representation on behalf of respondent number 4 and 5 when the matter is called. List again next week on a date to be fixed by the registry.
Obliged, my Lord.
Item 6.
Complaint.
Mr. Lordship, I am appearing for the respondent and I have just filed my vakalatnama, my power. So if this matter may be taken up after 2 weeks.
My Lord, as of
What
now,
is there in the
my
matter?
Lord, this is very simple one. This is for quashing of criminal complaint 1
JC,
2000.
where is the complaint? Let's see.
My Lord, the complaint is at
According to
page
you,
number.
it's a purely civil.
Definitely, it is recovery
All
of
right,
law.
let us see. Let us see the complaint.
Page number 35, Your Lordship.
Page number
35.
35. You are for the informant. You are for the informant. 35.
Yes, Lordship.
Yes, please read the relevant portion, not from page 35. Yes.
My Lord, actually, it is same. Everything is same with the FIR. May I please go to the FIR?
All
Because
right.
Before that, they filed FIR.
Which was converted into a complaint.
Yes.
Page
FIR is at, my Lord, 53.
53.
Yes. The thing is that she filed FIR, it was not registered because it was civil nature. Then after that, they filed criminal complaint.
Yes, please.
So the English version is start from 57. May I please read?
53.
Yes.
And the
No,
English?
the English start from 57.
Yes.
To OC, Bongkon Police Station.
Mr. JC, you don't read.
Okay,
need
fine.
to
I'll
read
just
all
go
that.
to the relevant,
Come to the relevant part.
the last part.
Not the last part. Marcy Pet Care. Read from there.
Okay, Lordship.
The second paragraph.
The second para, the loan having been availed in the name of Mercy Pet Care Lalnun Pui, we felt that executing agreement in the form of.
Where are you reading?
So 58, I read from page number 58.
No, read 57. Second para.
Mercy Pet Care
Yes.
deals in animal food and medicines and was previously owned by Lalnun Pui proprietor. Thereafter, I, Lalmuan Omi, used to work at Lalnun Pui's shop at Mercy Pet Care. By the end of 2022, Lalnun Pui and her family decided, Lalnun Pui is, here is the petitioner, decided to work as missionary and prepare to leave for Delhi. They have decided to sell some portions of Mercy Pet Care wholesale distribution as they are in no capacity to care for the said business. Lal Nun Pui said that there are many interested buyers for Mercy Pet Care inasmuch as 3 CR offer exists from person interested. And since I, Lal Monomi, has been working with her, and then since we are related, she told me that she wants to me the most to undertake the course of business. However, despite being eager to take up the business, I have no sums required for purchase of the said business, and that I am reluctant to avail loans for fear of fluctuation in the repayment, and told them to Lal Nun Pui, who in turn said that she can avail loans for her. As per her calculation, the duration for repayment would be around 5 years. Then Lal Nun Pui took me to several banks to inquire for loan. Punjab National Bank, Chan Mari Aizol manager, Pu James, advised us to avail the loan. A sum of 1.5 CR was attempted to be availed through Mercy Pet Care distribution. Mercy Pet Care being mutated to my name. However, PNB Imphal told me that New Farm cannot avail such amount. Since I cannot avail the amount, the loan in my name, after thorough discussion with Lal Nun Pui and PNB manager, the former has agreed out of her own will to apply cash credit loan in the name of Mercy Pet Care.
Let's make it in the next
Yes,
week.
sir.
Okay, anytime in the next week.
Article 7.
Yes, what is the stage? Are the parties duly represented, both the parties?
Yes, madam.
Yes, my lord. Ms. Lal Nun Pui is appearing on behalf of respondent 1 to 3.
Government advocate, huh? Where is she?
She have already filed her affidavit in position, my lord. She is having personal difficulties today.
This is for what? Admission hearing?
Admission hearing, yes, madam.
Pleadings complete.
Does it need extensive hearing or should we admit and then list it for hearing? At the admission stage, what is the matter about? At the,
This is challenge to the orders passed by the state government, order dated 6/9/2023 and order dated 29/2023, wherein the land of the petitioner was invalidated and a subsequent pass which was issued to the private respondents was validated.
so it needs some hearing?
Yes.
I don't think it can be disposed of in the admission stage itself. So we'll admit the hearing, we'll admit the this thing, writ petition and list it for hearing, isn't it? What is the background? Just give me some idea. Where's the landed property?
The landed property is situated at Bongkot, Brigade
Okay,
area.
when was it? So you have some documents?
Yes, we have valid documents. In fact, our land was issued prior to the issuance of the lands of the private respondents.
Okay, what sort of documents did you have?
House pass to LSS. We have all the required documents.
Okay. Then, when did you discover that your landed property was what, encroached or? So over the same land, another LSC was given to the respondents,
Yes,
is
my
it?
lord. Yes, my lord. And in fact, it was in the year 2016 that a civil suit was instituted before the senior civil judge. And in fact, 2 civil suits were instituted and both were withdrawn by the private respondents.
So not settled, huh?
Yes, it's not settled. And in fact, there's an eviction suit pending and that is kept in abeyance.
Eviction in your favor?
No, it's still pending, my lord.
But who is going to be evicted, you or the defendants?
Us.
We had filed against the
Okay.
petitioner.
Okay. So if it was withdrawn by the respondents, then how come there's a eviction, this thing, suit?
Exactly that they have filed, my lord.
Oh, so they had filed an eviction suit,
Yes, madam.
which is in their favor.
Yes.
The eviction
pending,
suit is
still
pending.
Still pending.
So when the eviction suit is pending, why have you come in form of writ petition? Let that matter be settled first, disposed first.
Notes pertinently, my notes, this writ petition throws up disputes of factual issues in nature, my notes. To be decided in a writ petition, my notes, that would be our
No,
first.
and when there's a eviction suit still pending, let the eviction suit be disposed of first, isn't it? It's still pending.
It's still pending.
So they don't know whether you should be evicted or not. Then you come running to the court in form of a writ petition, is it?
Yes, my lord. But unless
Then-
there's a
then-
challenge to the orders that was passed, the orders issued by the state.
Can't you raise that issue before the learned trial court? By filing a counter WS. That can be done.
All the suits that have been filed, we had filed it, my lords.
Huh.
They have never filed a suit. If they had a claim of title,
So even if you file a suit,
yes.
but they can also still file their
Counter.
written this thing, and in your counter you can have a counter claim also, saying this is wrong, this is my stand, this. Because supposing we dispose of this writ petition, that means we are just cancelling the eviction suit which is still pending. That cannot be done. So in admission hearing itself, it cannot be admitted.
If that's the case, my lord, let my senior appear and let the
Okay,
matter be
yes,
kept.
we'll have to see.
Yes, my lord.
So in the eviction suit, once the eviction suit is disposed of and there's an order for you to be evicted, then you file an appeal against that with whatever grounds you have, but you have to raise all those grounds in the eviction suit, which you have not. Have you filed written statement? Any
my lord,
counter claim, nothing?
Not at this stage, ma'am.
Then? Anyways, okay. Heard Mr. Roku Ngapautu, Learned Counsel for the petitioner, along with Mr. Jordan Rohintanga, Learned Counsel for respondents number
5 only.
5, and Miss Caroline K. Lalungoypui, Mrs. Lalungoypui, Learned Government Advocate for the state respondents, the Learned Counsel for the petitioner. We'll let Caroline, the proper this thing be represented also. See, it appears that there's an eviction suit pending
Yes, Lordship.
in the trial court. And in the meantime, you have come by way of a writ petition.
Yes.
So we'll have to look into the maintainability of the instant writ petition. But we will be fair, we will allow the concerned government advocate to be present.
Yes.
Then we'll fix it for admission hearing, whether this matter can be admitted in this form and style.
Yes,
So
Lordship.
my query is, when there's an eviction suit pending, then can you come before this court while the eviction suit is still pending? Because in the eviction suit, whatever ground you have in the writ petition, you can raise that by filing a counter affidavit, written statement, and make a counter claim saying that you have a right over the land. Then why have you come directly to the court in the form of a writ petition?
My lord, one thing is that we hear the main subject matters of the suit is that the order by revenue department. So we challenge that. So continuations after getting that order, they file eviction on the basis of that order, revenue order. So we challenge that order. So my lord, the thing is that before, on 2 occasions, they filed civil suit on 2015. First they filed.
That was, okay, that was withdrawn, that's a different thing.
And again they filed in 2016. Again withdrawn. Then they withdrawn, actually we object the withdrawal application also. We file review also.
They withdraw. You can go to the court also.
No, the story is that quite surprising. Then that the same party they had directly gone to revenue, so they got the order directly cancelling my pass. Because principle of natural justice is applicable in this case. And by that issue, or using that government order,
So do you have a eviction order from the court?
no, that first they filed it first order, then we file here and we got stay order by this honorable court.
Anyways, we will hear
Yes,
it in the
yes,
next
yes,
court
yes.
date. Let Lal Nunpui also be present.
Yes, need
Okay,
to be
because
present.
they're the ones who had issued the order, isn't it?
Yes.
Mr. JC, so and so. Okay, instead of this thing, Mr. JC is present. Learned counsel for the petitioner is present, along with Mr. John Rohing Thanga, learned counsel for respondent number 5. And Mrs. Caroline K. Lalnu, learned government advocate for the state respondents. The learned government advocate, okay, submits that this matter is handled by Miss Lal Nunpui, learned government advocate, who is not able to appear due to some personal difficulty. She has therefore prayed for adjournment. In view of the above, new para, in view of the above, list, when do you want it?
What about my lord, 12th June?
Why 12 June now? Okay, you are the petitioner.
Yes,
Okay.
Lordship.
In view of the above, as prayed for, list on 12/6/2025. Yes.
Yes, much obliged.
My Lord, I am for respondent number 1 to 3. I'm seeking another 3 weeks' time for filing my affidavit.
Yes, my lord, I'm representing the respondent number 4 and 5 and similar prayer, my lord. I'm seeking another 3 weeks' time.
I have received the copy of the affidavit from respondent number 1 to 3.
1 to 3 is whom? Ms. Zaram Sangpui. Mrs. Zaram Sangpui, automatically don't just pray for adjournment, see if you're filed also. Because when we see a face, it's always adjournments.
Yes, my lord. I have to check in, my lord. I'm sorry.
So have you filed? If the counsel for the petitioner has received your copy of your counter affidavit, then you must have
So
filed.
far as my knowledge, it's annexure is not eligible. That's why they have not filed. Even
Okay.
though before
Okay,
filing, they
so you want a short date.
yes, that's after 1 week.
But you're almost ready, that means.
Yes,
Okay, see here this thing.
Yes, madam.
What about Vanessa?
Yes, my lord. Now the Parawise comment is pending with the law department for vetting.
Okay.
2 weeks.
Miss Dinari Tiazu, learned counsel for the petitioner is present, along with Mrs. Zaram Sangpui, learned CGC for the respondents number 1 to
1 to 3.
1 to 3. Along with Ms. Vane Isiame, learned government advocate for state respondents number
4 and 5.
4 and 5. What about 6 and 7 then?
Your lordship is
Okay, none
see,
appeared for
yes.
respondents number 6
even though
and
they have
7,
received
though the postal consignment report shows that notice is duly served upon them. Full stop. Then Mrs. Zaram Sangpui, learned CGC, has prayed for a short date for filing of their counter affidavit, which is almost ready. The same prayer is made by Ms. Vane Isiame, learned government advocate. In view of the above, list after 2 weeks.
My lord, if it's possible, 3 weeks, my lord.
Okay, list after 3 weeks. We may also await for respondents number 6 and 7 to be duly represented. Yes.
Obliged.
Accused petitioner I. Srimati Mimi Lalumjui on bail who was arrested, yes, arrested on rearrest, who was
28/7.
whose earlier bail granted in connection with the pending trial connected with this case. No, whose earlier, Mashwar, whose earlier bail granted in criminal trial SR number 35/2023 was cancelled and was rearrested on 8/6/23.
My lord.
On 8/6/2023. Stop. Situated, the brief facts of the case is that on the evening of 28/7/2022 at around 3:25 p.m., the jurisdictional excise and narcotics officer seized 25.8 grams of heroin kept in 2 dark-colored soap cases. On said seizure of heroin, the petitioner was arrested and was booked in excise case number SES-184/2022, registered under Section 21B of NDPS Act 1985, dated 29/7/2022. Stop. Thereafter, the jurisdictional sub-inspector conducted investigation and seized the contraband articles and sent the same to FSL for examination. Stop. After receiving the report of the FSL and upon completion of the investigation, charge sheet was submitted before the Special Court NDPS criminal trial number 35/23, registered under Section 21B of NDPS Act 1985. Stop. Accordingly, a case was registered. No, that's right, huh? Just stay, don't say accordingly, full stop. Pursuant to the appearance of the petitioner before the Special Court, charge was framed against her under Section 21B of NDPS, so and so, and the learned trial court don't say that, just full stop. The learned trial court was also pleased to grant bail to the petitioner. However, during the pendency of the trial, while the petitioner was on bail, she was arrested in another case regarding the seizure of 12.70 grams of heroin, which was registered as criminal trial SR number 343 of 2023 under Section 21B of the NDPS Act 1985. And accordingly, her earlier bail granted in criminal trial SR number 35/2023 was cancelled. Subsequently, In the second criminal case, where is that second bail order? 2325, have you annexed?
Page 25, my lord.
The trial court granted the petitioner bail in BA number 14 of 2025 in criminal trial SR number 343/2023 by order dated 23/2025. Stop. Situated that having been enlarged on bail, the petitioner filed bail application number 16 of 2025 in the present in the criminal trial SR number 35 of 2023. However, the trial court by order dated 2/4/2025 rejected the same. Hence, the present bail application. Mr. So and so, learned counsel for the petitioner, submits that the petitioner has been languishing in jail since last almost 324 days. He further submits that since the petitioner has already been granted bail in the subsequent case, she may be allowed to go on bail in the present case as well. And that she will fully cooperate with and that she will appear on all dates before the trial court and shall not full stop. He further submits that it is discernible from the records of the trial court that she has been regularly appearing before the trial court and facing the trial from outside, facing the trial while she was on bail. Correct? Stop. Per contra, Ms. Mary so and so submits that it is apparent from the statement of the accused petitioner recorded under section 161 CRPC so and so, corresponding BNSS section so and so, that the contraband articles were seized from the possession of the petitioner. Stop. She further submits that while she was on bail, it appears that she was arrested in connection with another FIR relating to a similar offense. Correct? Stop. I have given my prudent considerations to the arguments advanced by the learned counsels appearing for both parties and have perused the materials available on record. Stop. It appears that the trial in criminal trial SR number 35 of 2023 in criminal trial, out of 6 witnesses, only 3 has already been examined. It further appears that the remaining 3 are the judicial magistrate who has recorded the 164 CRPC statement and 2 official witnesses of the narcotics and so department, correct? It further appears that during the period the petitioner was on bail in connection with the criminal trial in question, she had been regularly appearing before the trial court on all dates. The object of bail is not punishing the petitioner, but to secure the attendance and appearance of the petitioner before the trial court. It further appears that the petitioner has been it further appears that there is no apprehension projected before this court on behalf of the investigating officer that in the event the petitioner accused is released on bail, she shall flee from justice. That being so, this court is of the opinion that further detention of the petitioner in connection with the subject criminal trial is not justified. Accordingly, the bail petition, then you give that whole thing, it is provided. How much? 50,000 or 1 lakh? Miss Mary? Tell me.
50,000.
50,000?
My lord, 30,000 has been imposed in the...
All right. Be grateful that you are getting it.
My lord.
You want me to cancel it? I can do that. Miss Mary, satisfaction of?
To the satisfaction of the learned trial court, yes.
Trial court, okay? And give all those NDPS conditions allowed.
Highly obliged.
Item 8.
Yes, Mr. Lalfabiwala, what is
Please,
this
Your Lordship.
impleadment?
As directed by this honorable court, I have
Yes.
produced the full set of
Huh?
I have produced the full set of the judgment and order passed by this court, which
Oh, this is that
Yes,
matter
that's
which
that
had
matter.
earlier come.
now the person which we have sought to implead is the respondent number 1.
Yes.
The respondent number 1 is the Secretary to the Government of India, Ministry
Yes.
of Home Affairs, Department of Border Management.
Where is it?
See.
Give Elsie.
Your Lordship will see at page 107.
Page
107, man.
107.
Yes, my lord. Has your lordship got it?
Yes. Yes.
Now, the reason why we have sought to implead this person only at this stage,
Which one?
this respondent number 1, is because of the fact that in the original judgment and order passed by the learned single judge, your lordship will see at page 126 in the contempt petition.
116.
126.
No, this judgment that you
Yes, my lord.
in this, where do I find
Yes.
it?
In this judgment, your lordship will see at page 114, para 13.
Page?
Page 114, para 13. Now it has directed the respondent number 3 to 6.
One sec. Why today all of you are in such a hurry? Go slow. As it is, there are not much matters on the board.
All right, thank you, my lord.
Yes.
I'll go slow.
Yes. Page 114, yes.
Page 114, para 13. Now, this Honorable Court has directed the respondent number 3 to 6 to make necessary arrangement of funds on a calculation to be done by the collector. There is the respondent number 7. Now, the respondent number 7...
One sec. The collector shall forward the same to the... let's read from... now, they will forward the same means? What is the same?
Yes, the collector has made an assessment.
Where do I find that in this order? I think, Mr. Alfaqjola, let's start from para 11, then it will be cleared.
All right, ma'am.
Paragraph 11.
With your lordship permission?
Yes, please.
Upon considering the case in its entirety, the respondent number 3 to 6 cannot be allowed to make the objection they have raised at this stage without them having taken recourse to a remedy as may be available in law. They are therefore liable to pay the compensation amount as awarded by the district collector, less the amount already paid by them. The petitioners will also be entitled to the solicium and interest as calculated by the additional district judge Lunglei in civil miscellaneous application number 33/2015, para 12. Besides the above amount, the district collector district Longklai shall calculate the amount of interest payable to the petitioners in terms of Section 34 of the LA Act or Section 80 of the Act of 2013, and also in view of the award of solicium and interest by the additional district judge. The petitioners will also be entitled to the benefit under Section 28 of the LA Act or Section 72 of the Act of 2013. The district collector Longklai...
Who is the district collector? Respondent number?
7. The district collector district Longklai...
So you have made 7 a party?
Not a party, because the district collector has complied with the order of this court.
All right. Shall make appropriate calculation.
Calculation on the interest payable to the petitioners as stated herein above, which in fact should be for the entire amount of compensation, that is including the solicium and interest. Such calculations should be done within a period of 6.
This part of the order has been complied.
It has been complied by the
Now,
district
upon making such calculation,
upon making such, shall forward the same to the respondent number 3 to 6, who shall make necessary arrangement of the fund record as expeditiously as possible and preferably
so
within
his direction is to R3 and 6, to R3 and
R3
3 to
and
6
are the NPC
to
authorities.
make necessary arrangement of the fund
Yes, madam.
as expeditiously as possible and preferably within the period of 3 months of the requisition.
Yes,
all
madam.
the respondents, okay, there is also saying all the respondents shall coordinate
Yes, madam.
and ensure that the petitioners get their due compensation with delay, without delay. So, all right.
Now, this case has already gone to the Supreme Court, and the Supreme Court has dismissed the SLP. Now, why I am filing this application is because the respondent number 3 to 6 has sought to rely upon the respondent number 1
Where is that?
for the fund sanctioning authority, madam. I'll take a lordship to the order of this court, dated 29/4/2025, madam.
In the contempt petition?
Yes, madam. In the IA application, madam.
In the IA application?
Yes.
Yes. Where?
Page 28 to 32.
Page 20?
28.
Yes.
Now the relevant portion is at page 32, my lord. I'll just take a lordship directly to page 32 to make my submission short, my lord.
Sorry?
I'll take a lordship to page 32.
Yes, please.
Now let this matter be listed again on 29 May 2025. It is made clear if there is no positive indication with regard to the compliance of the court's direction by the next day, the personal appearance of the respondents concerned may have to be directed. The communication dated 13/3/2025 produced by Mr. Roshan Subedi, Learned Counsel, is retained on record and marked as X for identification. Liberty is granted to the petitioners to implead the authority concerned of the Ministry
Very
of Home
well.
Affairs, my lord.
Why you didn't show me this on the last occasion? Huh? There is already an order.
Yeah, there is an order. I was about to show your lordship on that date, but I don't know why I am.
All right, Mr. Subedi.
Yes.
Heard Mr. C. Lalfat-Jwala, learned counsel, appearing for the applicant. Also heard Mr. Mr. R. Subedi, learned counsel, appearing for the respondent.
4, 5, 6.
Numbers 4,
4, 5, 6.
4, 5, and 6. Stop. By way of this application, the applicant is seeking impleadment of SH so and so. You will find it at page 3 of the course title, okay? Of so and so, Secretary to the Government of India, Ministry of Home Affairs, Department of Border Management, room number so and so. All right, everything as an arrayed respondent number 7 in the contempt petition C number 25 or 2021. Stop. The brief facts of the case is that the contempt the connected contempt petition has been filed for alleged willful disobedience of the judgment and order dated 4/12/2019 passed by this court in WPC number 71 of 2018. Stop. However, at the time of filing the contempt petition, the proposed arraignment of the respondent was not has not been arrayed there as a party respondent, as the direction of the court was for the remaining respondents to comply. However, during the pendency of the contempt petition, it appears that the presence of respondent number of the proposed respondent, arrayed respondent, is essential for effective adjudication of the contempt petition, and hence the present impleadment application has been filed. Mr. So-and-so, learned counsel for the applicant, draws the attention of this court to the order dated 29/4/2025, passed in this contempt case, passed in the connected contempt case, whereby the applicant was granted liberty to implead the authority concerned of the Ministry of Home Affairs, if so advised. Stop. Mr. So-and-so has no instruction, submits that he has received no instructions to oppose the said prayer. Heard so-and-so. It appears that the presence of the concerned officer, present of the authority concerned of the Ministry of Home Affairs is essential for effective adjudication of the contempt petition. Accordingly, the impleadment application stands allowed. It is provided that so-and-so be impleaded, give the whole thing, be impleaded as a party respondent number 7 in the contempt case so-and-so, so-and-so. Let an amended copy of the cause title be submitted before the registry for doing the needful.
Obliged.
Application stands disposed of.
Obliged.
In the contempt, you say, in view of the order passed on so-and-so, and upon receiving the amended cause title,
lists the matter. My lord, there is a fixed date. 29 May.
All right, then I don't think I need to say
Yes,
anything.
vote on. Obliged.
Yes.
Item number 9.
304 days delay. Huh?
Yes, my lord.
Yes, but
With your lordship permission,
why? Yes, yes.
I had filed additional affidavit.
That is my precise point. Why the pleadings of this condonation application has become so voluminous? Objections, additional affidavit. The only thing that needs to be shown before the court is that you had sufficient
Your lordship, the respondents have not filed their objection in the condonation application.
304. What is your what is the ground for delay?
My lord, the applicant purchased a residential building on December 12, 2022 from the respondent number 2. However, without his knowledge, the said plot of land has been ordered and decreed in favor of the respondent number 1 on the order and decree dated 25/9/2023 in civil suit number 40 of 2023. The applicant came to his knowledge on 4th of April 2024. He never knew that that suit was existed before. So he followed the respondent number 2 to the court premises. At first he thought that there was some dispute arose and nothing. So on 4th of April he came to learn that the respondent number 1 had already won case against the respondent number 2, and his property has been ordered and decreed in favor of the respondent number 1. So he filed review petition on 16th of April.
Where are the grounds stated in the petition?
That I have filed in my additional affidavit.
The grounds are not there in the condonation application.
My grounds are there.
Where? Why should this court first go to the additional affidavit? Show me where are the grounds in your application.
If I may take your lordship to page number 3 of my application. At para number 2, the applicant gained knowledge about the institution of court case.
One second. Para number
2.
Yes, please.
The applicant gained knowledge about the institution of court case and the final order passed by the trial court on 4/4/2024. In this connection, it is submitted that in the last part of March 2024, some person seemed to be the lawyer engaged by the opposite party number 1 approached the applicant in his house by telling that he and his family might need to be ready for moving out from their house from the second week of April if the opposite party number 2 still fails to make repayment of money on 4th of April, and they feel that the Honorable Court may pass order for locking the 2 RCC building, including their residence. Hence, the applicant, aware some disputes exist where his building was involved, he therefore consults a lawyer who advised him to follow Pilian Kumi, that is the opposite party number 2, secretly to the court for gaining knowledge about the actual condition of disputes. Accordingly, on 4/4/2024, the applicant, by following the opposite party number 2 up to the court premises, district court, ISO, and come to realize that the opposite party number one had already won civil suit number 40 of 2023, and now an execution case number 16 of 2024 is pending before the court for payment. Hence, the applicant gained knowledge only after 195 days after passing order and decree, or 105 days after period of limitation. After having such knowledge, the applicant engaged counsel who firstly inquired the documents available on records, and after having some knowledge that the LSC number 796 of 2008 purchased by the opposite party number 1 from the opposite party number 2 is vacant land, and the 2 RCC buildings appearing in the compromise agreement dated 6/9 of 2023 signed between the opposite party number 1 and opposite party number 2, an order and decree dated 25/9/2023 in civil suit number 40 of 2023 situated and located in another LSC. As such, the learned counsel firstly approached learned counsel for the opposite party number 1, with whom he had some discussion. And out of their conversation, it is also an admitted fact that fact by the learned counsel for the opposite party number 1 that if the RCC building was already purchased by the applicant, the opposite party number 2 has no right to give consent for the transferring the same to any other person and could not mention in the said compromise agreement. Since the applicant is affected by the order and decree as well as the compromise agreement, he is one of the necessary parties to be impleaded in the case. And in order to implead as party, it is possible for the applicant to file review application before the same court. Besides, during the conversation, the learned counsel for the opposite party number 1 also fairly stated that if the personal inquiry is correct, filing of review petition may be good even for them to have a firm and re-examining their case on merits, and there would be no prejudice even for the opposite party number 2. Hence, the applicant filed review petition number 9 of 2024 together with CMA number 297 of 2024. Hence, the applicant thereby takes another 22 days. That unfortunately, the review court had dismissed the review petition by its order dated 26/9/2024, thereby pending before the court for a period of another 151.
There is sufficient explanation, Mr. Counsel. There is sufficient explanation.
My lord, if I may make one small submission
yes.
Before coming to this instant IA. The instant case has been filed as a third party appeal, and IA number 178 of 2024 has been filed seeking leave of this court to file a third party appeal. So, my lord, it is my humble opinion that the said IA 178 ought to be disposed of first, my lord.
Oh, that is seeking leave.
Yes.
But how can, without condonation, one will take the leave application? I think.
My humble opinion, my lord, if condonation or delays has been admitted, if the instant IA is admitted, then, my lord, that would mean that the leave would have been allowed, my lord.
No. Why will it mean?
It is my humble opinion.
Why will it mean
as
that?
Such,
because you see, there are two things.
Yes.
They need to file a leave application for appeal, right?
Yes.
Now, if suppose it is barred by time, then
My
there
lord.
is no question of leave. There is no question of granting leave.
My lord.
The question of granting leave will only come if the delay has been condoned.
That was my humble opinion, my
So
lord. But
first the
my
court has to
submission-
take up. So now this IA 177 is the condonation.
Yes.
So that has to be first taken up.
It was my humble belief and opinion that, my lord, according to my understanding, that the
but
leave will have
Mr.
to
Counsel,
be disposed of
there
first.
is a procedure.
That was why, my lord, I have submitted.
Mr. Counsel, there is a
yes.
procedure. Have you looked into the CPC?
My lord.
Your humble opinion is no good.
That was why I have submitted WO
Your
in
humble
respect of
opinion
the.
is no good, Mr. Counsel.
Yes.
Have you seen the CPC?
If I may be allowed to.
Are you carrying a copy of the CPC?
If I may be allowed to submit WO on the condonation delay, my lord.
Huh?
If I may be allowed to submit WO.
WO?
Yes. Written objection on the. My objection
You
on
have
the.
already given.
I have given in IA 178.
No.
I have
No,
not given
no,
in
no,
the delay.
No further time. No, nothing doing. Why should these condonation applications be kept pending for such a long time? No. This is a 24. This application is going on. It was filed on 13 till November 2024. Matters can't go on like this.
My lord, in the last court, on the last court date, on 6/3, this honorable court was considering IA number 178.
How can this be done? Unless and until the delay is condoned, how can the question of granting leave will come? The question of granting leave can only come after the condonation is, I don't know, you check the position, you must assess the court. You must assess the court. CPC.
If I can take your lordship to the order passed on March the 6th, my lord.
Which order?
6th March 2025. The instant applicant was also filing yet another IA, that is IA number 37.
Which order? 20?
6/3/2025, my lord. 6/3.
6/3.
Yes.
That order is in which file?
IA number 37 of 2025. There's another IA. The instant
Show me the
applicant
other
has-
IA.
Yes, the instant applicant has submitted.
Where is the other IA? IA 1?
IA 37.
There
37.
is- I don't have IA 37.
IA 37 of 2025,
1 second.
my lord.
Yes, what do you want to show?
My lord.
This IA 37 was for amendment.
Yes.
That
and,
was
and
allowed.
that talks about IA number 178, leave, my lord.
So what does it talk about? Does it say that 178 has to be taken up for the before the condonation?
That particular thing
Then
has not
why
been
are you
mentioned, my lord.
misguiding the court? What is the point of showing this order, Mr. Counsel?
My lord, that this court did
What
that.
is the point of showing this order, Mr. Counsel?
My lord, that this honorable court has taken up this instant IA for leave application.
Mr. Counsel,
Yes.
what was this IA for? This IA was for making some correction.
Yes, yes.
Correction where? Correction in both the IAs and
My
the RFA. Please read your prayer. Allowed to make amendment in RFA number 35 of so-and-so and interlocutory application number 170 of so-and-so.
Yes.
And then what does the order of the court says? Is it so difficult for you to understand the order of the court? And you see, you are unnecessarily wasting the judicial time of this court by showing all this. Kindly see what is this order. Accordingly, the learned counsel for the applicant is allowed to make the corrections as stated by him in the application by replacing the pages wherein the correction is required to be made. Thereafter, after making the said correction, copies of the corrected IA number of so-and-so to be furnished to the learned counsel for the respondents. Accordingly, IA stands allowed and dismissed. List the RFA and connected IAs.
Yes, my lord.
Connected IAs. After 2 weeks, then what is to be done? Now the delay condonation obviously has to be taken up.
Yes.
Unless the delay is condoned, how can this court proceed?
And in that regard, my lord, I have prayed this honorable court that I may be given time.
What time
for
do you want?
For filing objection, my lord.
Why have
to
you
the
not
delay
filed
condonation, my
time?
lord.
Why have you not filed your objection till now? What were you doing?
My lord, the instant applicant had filed additional affidavit.
As prayed for by Mr. So-and-so, learned counsel appearing for the respondent, relist this matter after 2 weeks on a date to be fixed by the registry to enable the respondent file their objection in the condonation application.
Obliged.
Item 10.
Yes, 83 days.
Yes, my lord.
May it please your lordship, I'm appearing for the applicant appellant.
First time? No. Yes.
My lord, this is a condemnation of delay for an unintentional delay of 83 days, my lord.
In filing the connected regular first appeal?
Yes, my lord.
Yes. What are the grounds? Any objection?
Yes, we have filed the affidavit in opposition, lordship.
Serious objection?
Yes, it is a serious objection.
All right. What are the grounds?
My lord, I have given explanation on the grounds from page number 3.
1 second. I'll see. When you give me the IA, don't give everything. It's too bulky to be captured. Give this when I need it. Just put it here. This it all falls down. Okay.
My lord, page number 3, para number 2.
Page number?
Page number 3, however, para number 2 is continued here on page number 3.
Yes,
So,
read.
Yes, my lord. The judgment and the impugned judgment and order dated 26/2024 was not furnished to the counsel for the applicant appellant. Therefore, on the day itself, the counsel for the applicant appellant at the lower court applied for certified true copies of the judgment and order dated 26/24, and the same was issued on 26/6/24. On receiving the judgment and order dated 26/24, the counsel for the applicant appellant at the lower court contacted the applicant appellant to meet her on 28/6/2024. That on 28/6/2024, the applicant appellant had a meeting and her counsel informed her that whether she would be interested to take up her case for appeal. The applicant appellant finally made a decision on 5/7/2024 to take up her case for appeal and informed the same to her counsel. The said counsel immediately took efforts in securing a competent advocate for the applicant appellant to represent her. However, as the courts are closed for summer vacation from the dates between 8 July to 12 July 2024, no effective steps could be taken. That the applicant appellant, with the assistance of her counsel, continued to search for a competent and suitable advocate and was finally able to contact the advocate, namely J.H. Ramne Moya, on 26/7/2024. The advocate J.H. Ramne Moya, after meeting up with the applicant appellant, decided to go through the case, and thereafter, on 31/7/24, the said advocate informed the applicant appellant that he would be willing to take up the case for appeal. As the advocate J.H. Ramne Moya was in the midst of the case study and for appeal of the case, a notification number, such and such, my lord, I have given under annexure 2 and 3, which is in pursuant to the appointment to one vacant post of Grade 1 Mizoram Judicial Service, that as Advocate J.H. Ramne Moya pursued the said examination, for the present appeal could not be taken up promptly. Thereafter, the Guwahati High Court issued another notification, which is given under Annexure 4, wherein the Advocate J.H. Ramne Moya's name was enlisted amongst the qualifying persons selected for mains written examination Grade 1, direct recruitment, Mizoram Judicial Service, which was to be held on 22nd and 23rd November 2024. Since the applicant appellant has been prolonged and delayed due to the said advocate's unforeseen and unintended delay, the said advocate informed the applicant appellant to meet him on 14/11/2024 to have a discussion on how to continue with this present appeal. That on 14/11/2024, the applicant appellant had a meeting with the said advocate and came to a conclusion to look for another suitable counsel as suggested by the said advocate. That the applicant appellant approached the present counsel on 19/11/2024 and handed over all the required documents. The present counsel informed the applicant appellant that she would require at least 2 days to go through the case before confirmation. That on 22nd/6/2024, the present counsel...
What is your objection?
Our objection is that this delay of 83 days is purely negligence, Lordship.
What are the negligence? They have been
Negligence
clearly
is-
explained.
Yes, Lordship. As soon as the judgment was pronounced on 26/2024, the council were addressed stating whether they are going to prefer the appeal or not. So they said that they are not going to file any appeal. And on our second approach, they said that they are going to appeal.
Yes, what is wrong in that? Now, for that you are going to, just because initially they thought they may not go for an appeal and subsequently they decided they will go for an appeal, this court is now going to close its door?
No, Lordship,
What
there is no
because
significant
Ms.
obstacle.
Counsel, what is the parameter which needs to be seen for either allowing or not allowing a condonation application? What is to be seen? Please tell me. What is the relevant factor that has to be seen? That whether the petitioner has acted bona fide or not, whether the explanation is sufficient or not.
Yes, Lordship.
The delay condonation is ultimately the discretion of this court, right?
Yes, Lordship.
Now I have read the grounds.
Yes, Lordship.
It doesn't appear that the petitioner has been, applicant has been deliberately delaying the matter. Initially, for some reason, and it is not like the petitioner took a lot of time also to decide.
Yes, Lordship.
Maybe for financial constraint, maybe for so many XYZ reasons, one might not first think, I'll go for an appeal. And subsequently has changed. Thereafter engaged a lawyer. In the meantime, that lawyer was selected, and then there has to be a change done. These are all beyond the control of the applicant. Why should this court close this matter right here and not give a chance?
Yes, Lordship.
Isn't it?
Yes, Lordship.
Anything else?
Yes, our main objection
Yes.
is that there was no significant obstacle nor significant cause on the parties, but in fact...
No significant?
Cause on the parties, but in
Cause.
fact... Yes, Lordship.
Okay.
There is no significant obstacle, Lordship. The
Okay.
examination which he has given, he knows that he's going to give the examination. This is just
Noted.
an inordinate
Anything
delay.
else? Anything else? All right, please take down. Counsels, you may take your seat. This is item number 10, huh? Okay. Heard MS Lalrinpui.
C. Lalrinpui.
Huh?
C. Lalrinpui.
C. Lalrinpui, learned counsel for the applicant. Stop. Also heard MS
Rosalind Elmar.
Rosalind Elmar, learned counsel, appearing for the respondent.
Yes,
Stop.
Lordship.
By way of this application, under Section 5 of the Limitation Act 1963, the applicant is seeking condonation of the delay of 83 days in filing the connected regular first appeal against the impugned judgment and order dated 26/2024, passed by the Learned Civil Judge, Senior Division number 2, Aizawl District, Aizawl, Mizoram, in succession, case number 655 of 2018. Stop. The brief facts of the case is that in the succession case, you were representing the
applicant, appellant.
applicant. The brief facts in the case is that in the succession case number 655 of 2018, filed by the applicant,
Yes, my lord. My lord, it was a different counsel in the, who represented.
but you are the applicant,
Yes,
right?
my lord. Yes, my lord.
Filed by the applicant upon, so that was not allowed.
Yes, my lord. No, actually, my lord,
Upon the judgment and order being pronounced, comma, the applicant being aggrieved has preferred the connected regular first appeal. However, there has been an unintentional delay of 83 days in filing the connected appeal. Hence, the present present condonation application. Stop. MS so and so, learned counsel for the applicant, submits that the delay is totally unintentional and has been occasioned due to the time taken for engaging a competent counsel, and since there has been some development for which the engaged counsel could not continue with the preparation of the appeal, further time had been taken for re-engaging another counsel and filing the appeal. Stop. Per contra, MS so-and-so vehemently opposes the condonation application by saying that there was no serious hurdles for the or obstruction for the applicant to prefer the regular first appeal on time, and the grounds are not sufficient and bona fide for condonation. Stop. I have heard the arguments advanced by the learned counsels appearing for the contending parties and have perused the materials available on record. It appears that in filing the connected regular first appeal, there has been a delay of 83 days. Stop. The grounds of delay, as explained in the condonation application, reads as under. Paragraph 2, 3, 4, 5, 6, 7, 8, 9. Okay, quote unquote. The reading of the aforesaid averments, it appears that though initially the applicant took some time to decide as whether the applicant will file the appeal or not, however, after deciding to file appeal, the applicant, after engaged the services of one counsel, who, however, during the preparation of the appeal was selected for mains written examination, grade 1, direct recruitment, Mizoram Judicial Service, and therefore the applicant had to later on re-engage the present counsel, who after perusing the documents prepared the appeal memo and has filed it. It is in the aforesaid events that a delay of 84 days has occurred. That being so, this court is fully satisfied that the delay has been sufficiently explained and the same is bona fide. Hence, the delay of so and so day stands condoned, delay application stands allowed. Is the connected appeal already registered? Okay. In the RFA so and so, you say, in view of the order passed in so and so, list when? Next week on a date to be fixed by the registry.
Lordship, we have not received the RFA 49
All
of
right.
2024.
So you give,
Yes,
maybe notice is not issued.
Yes.
Anyway, you give a copy.
Yes,
I am not doing anything in that RFA. I am only fixing it.
Okay, Lordship.
Okay. Yes. Disposed of.
Obliged,
Much
Lordship.
obliged.
Councils, if you permit, can I just quickly go to the restroom and come?
Item 11.
My lord,
Yes.
this is the first
First
time. My lord.
time.
Yes.
All right. Where's APP? Issue notice when?
My lord, Friday.
Not Friday, Monday, next Monday.
Yes, my lord.
Issue notice and call for
Call for record, my lord.
records or scan copy.
Scan copy will be fine, my lord.
No, if you have to get it from the investigating officer, that is different. That's why I'm asking.
I have to get it from the court, my lord.
From the
Court.
How can you get it from the court?
The charge sheet copy, my lord.
Okay. All right. Let the call for records. Simply just say that. Fix on Monday.
For hearing. Item 12.
My lord, before